Yes.
Okay. Ma'am, at the Wayne County Jail, can you state your name? Unmute the device and state your name, please.
Portia Thomas.
Portia Thomas. Okay.
That was from last week.
Attorney Squad, do you want to wait for your client? I was trying to get Wayne County Jail to put your client up.
I will wait.
Okay.
Thank
give me
you.
a moment. They log on, I'll have him brought up. Ready on McIntosh?
Ready.
State of Michigan City, Detroit, Michigan City, Court of Session, the Honorable Judge Aliyah is presiding. Good morning, Your Honor.
Good morning, everybody.
Morning.
Start off with McIntosh. Case 2355623, the people of the state of Michigan versus Talon McIntosh, charged with 1 count of stolen property, receiving and selling a motor vehicle set for a probable cause conference appearances.
Alexander Kirker on behalf of the people, 886-286.
Good morning, Your Honor. For the record, Jeffrey Glazer, P 46892, on behalf of Mr. McIntosh.
And Mr. McIntosh, he's not present, correct?
Yeah, Judge, this was, Your Honor, this was put over from last week. If I could try to locate him. I did send a letter. Nothing came back. I also emailed him. The phone number I have is not a good phone number. I don't really have any explanation as to his whereabouts. I thought he might be in the jail, but I'm assuming he's not on the jail list. So really don't have an explanation as to where he is, Judge.
Let me confirm that he's not on the jail list. Thank you.
He's on tether.
Okay, yes, he's out on tether. All right, anything from the people?
In this instance, people would ask for a KPS, Your Honor.
Okay, I will issue a KPS. It'll be $1,000 personal.
All right, Judge, if for some reason he does come in, certainly I'll be available later this morning.
Okay, all right.
Judge,
Thank you. Have a good day.
you too.
Thank you. It's not, she's a woman, but yeah, we don't have a date, so people are still talking about office. Okay. Yeah, have a good day. Bye-bye.
I have another courtroom to check into. Can I come back, please?
We're ready on
My client doesn't
McIntosh.
seem to be here yet.
Not McIntosh, excuse me. Mr. McIntosh,
Yes.
I just called your case. Your client, your lawyer just logged off. I was just signing paperwork to issue a warrant. Okay. So your client, your lawyer's been trying to contact you for 2 weeks now.
I don't know how, because he has all of my contact information, and I've tried to call around and call people. I even asked my tether officer to contact me, and nothing.
Okay, what's your phone number?
586-457-6479.
Okay, we have a different phone number. All right, I'm gonna give that to your attorney and take down his number. Let me know when you're ready.
I'm ready right now.
313-963-4321.
Okay.
Don't hang up.
313-963-4321.
Yes, don't hang up. Pretty crazy, your plan back, that's just log on to log on. So you can get back on 360-438-0000. Just wait a second, Mr. McIntosh, I'm gonna have, see if the lawyer calls back.
Okay.
You said, don't hear it, so this is March 13th, that's it.
They both broken. Did I respond?
You said, yeah.
And they didn't respond back?
Send me a person.
Oh,
Send it, send it. Keep it adjourned. Just in case,
I know, I'm sick.
Mhm. Yeah.
Mr. Frank? Unmute your device.
Hear me?
I can hear you. Yes. Their case has been adjourned to March 13th at 10 a.m. in person.
March 13th.
10 a.m. in person, yes. The lawyers both agreed to an adjournment. One of the lawyers needed another day.
Okay, thank you.
You're welcome. Have any other questions about your court date?
No, that's it.
Okay, have a good day. Marla Jordan,
Hi,
good morning, Ms. Jordan.
I was here for support. I don't know if I was supposed to go this way or the live stream.
You're here for what?
Support. I didn't know if I was supposed to go this way or the live stream. I don't have a court date with you.
Support.
Somebody, yeah, somebody else has a court date with you.
Who is it?
Cindell Braceley.
yes.
Okay. Yeah, log on to YouTube. That's how you're supposed to watch it.
Hit the YouTube link.
Yep, 438.
All right. Thank you. I appreciate that.
You're welcome. They haven't checked in yet, just so you know.
Okay, thank you.
Also, I just received information that this is not going to be an exam day. It's going to be a probable cause conference.
Okay.
We didn't know testimony today.
Okay. All right, ma'am. I called 36 District and they told me to hit the link, and I kind of figured since I didn't have a date with you, I needed to go through the Zoom, the YouTube, but I wasn't sure and I wanted to make sure I could see, what I needed to know or whatever.
Yep, you didn't miss anything.
All right, well, I thank you. You have a great day.
You too.
Bye.
Okay, Mr. McIntosh is here. Oh, we still don't have Mr. Go ahead, please. Radio Williams?
Yes.
Anthony? Okay.
Yeah.
That was boss call, Mr. McIntyre. Sorry, that wasn't, I thought your attorney was calling.
Okay.
Okay, this is the people of the state of Michigan versus Anthony Williams, 2355533. Mr. Williams is charged with one kind of controlled substance, delivery, manufacture of marijuana. Day-to-day set for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P 86282.
Good morning, Your Honor. Steve Mencken, P 31562, appearing on behalf of Anthony Williams.
Mr. Williams, please state your name for the record, please.
Anthony Williams.
Good morning. Attorney Macon, do you have discovery on this case?
I do, Your Honor.
Okay, any other preliminary matters that need to be discussed?
Well, I discussed this with my client. He's 24 years old and he can probably qualify for HIDA. Maybe we can work something with 7411. So I was thinking, unless I can do something down here, because I didn't get to talk to the prosecutor, we would just waive the exam and take it up to see if we can do something. He has no prior record.
Okay. Mr. Kirker, how does that, do you usually have the third circuit prosecutors handle it?
Typically, yes.
Okay.
Sometimes we can, but it's usually the third circuit.
Attorney Macon, did you hear what he said?
Yeah, so if not, really, we can't do anything here with it unless he thinks we can. We could put it for another PCC. If not, we can just waive it up, which I discussed with my client.
Okay, let's, if he's comfortable waiving his exam, I know across the street they can handle it.
Okay.
Mr. Williams, I'm gonna ask you a series of questions, okay?
Okay.
Is it your wish to waive this exam today?
Yes.
Okay, you understand you have a right to an exam?
Yes.
And that if the prosecutor were to hold the exam today, they would have to prove, or not hold today, but when your scheduled date of your exam would be, that they would have to prove at the probable cause standards that the one charge that I read off was committed in the city of Detroit and that you probably committed that crime. You understand that?
Yeah.
Okay, and knowing that information and that the people do not have to prove that, do you still wish to waive your exam today?
Yeah.
Okay, did anyone force you or threaten you to waive your exam?
You said what?
Did anyone force you or threaten you to waive your exam?
No.
Okay, did anyone promise you anything in exchange for your waiver?
No.
Okay, I find your waiver to be freely, understandingly, and voluntarily given, so I will have you bound over to Third Circuit Court, Frankfurt Hall of Justice, for an arraignment on the information dated March 20th at 9:00 a.m.
Okay.
Thank you, Your Honor.
You're welcome. You all have a good day.
You too.
Thank you.
I have to check in at another court. Can I come back later?
Yeah, I talked to her. He's gonna be in 803.
Yeah.
Attorney Elijah?
Good morning, Your Honor.
Good morning. Who are you here for today?
Can you hear me okay?
Yes, who are you here for today? Attorney Elijah, who are you here for today? Are there any attorneys ready for their case to be called?
I have to take off. I have
Yeah.
to go into another courtroom.
I know you keep saying
How
that,
did
but
that
I
go?
don't know if you're talking to me or not, because I'm not sure.
And Mr. Bracy should be in the Wayne County Jail.
And Attorney Schlapp, I have your concern, I'm trying to stay along that. Trina Bracy, if you don't have a case today, you have to log on to YouTube to hear our proceedings. Unless this Bracy individual is Shondell. Attorney Rushing.
Good morning, Judge. I'm here on the Bailey and Carter matter. I guess a motion was added up for this morning.
I don't have that on my docket. I don't even know what motion this is, will be for.
The people are requesting an adjournment of the exam that we were scheduled for tomorrow.
What's your client's name?
Keon Carter. They filed it over the weekend.
Mr. Kirby, did you file it?
It was Ms. Narcissian.
I didn't get anything in my inbox. Okay, to the Wayne County Jail, good morning.
Good morning, Judge Sabree.
How are you?
I got Miss Portia Thomas for you.
She doesn't have an attorney as of yet. I believe we need to get her one assigned. This is a tether violation.
Yes, ma'am.
Okay, we have to call over to Third Circuit to get an attorney signed.
Yes, ma'am. We'll wait.
Okay, in the meantime, do you have a Shondell Bracy?
You say Bracy?
Yeah, B as in boy, BRACY.
Let me see if we still have him in custody because he's not on my list.
Okay.
You have his first name, ma'am?
Oh, I'm sorry, Shondell, STANDALE.
Let me check.
Your Honor, if I may, I'm wondering if he might have been brought over to your courtroom.
He's here.
So I think there was a mix-up. This is the one that came over from Judge King's courtroom last week. And you set it for today for a PCC, but somehow in the 36th District Court docket, they have it set for a preliminary exam. So I think that's why he might be there. Shall I come across the street and hold it in person, the PCC?
You don't have to do all that. I can have him still come out here and you can be on Zoom if that's okay.
Very good.
Okay, let me have, when I get an officer in here, we'll have him come out.
Thank you.
Thank you.
Excuse me, Judge.
Yes.
We have Mr. Bracy. My partner's going to get him. I'll let you know when we have him in the room.
Okay, I have word that he's in person at 36, but if you have him, that'd be great.
Yes, ma'am.
Thank you. Okay, Mr. McIntosh.
Yes.
Attorney Blair, so your client is here.
Can I briefly go in a breakout room with Mr. McIntosh, please?
Sure.
Yeah.
Mr. McIntosh, hit join on your screen. We're going to a breakout room.
Gracie.
Was in custody.
Right. So I didn't.
What happened?
She wanted to know if it was over here or not yet. So.
Attorney Lamb, good morning. Attorney Lamb?
Good morning, Judge Sabree.
Good morning, how you doing?
I'm sorry.
How are you?
I'm doing well. I'm doing well, all things considered. How are you?
Pretty good, just trying to get
Gracie,
this morning docket, a little rough.
Understood. Understood.
You have Mr. Dickerson, correct?
Correct.
Is he in custody, do you know?
He can't. Oh, he can't.
He is out of custody. He should be available via Zoom.
Okay.
This was adjourned from last week. I'm sorry.
Have you had any contact with him?
I had telephone contact with him. I provided him the Zoom ID information for this morning. He did communicate to me, though, that he was in a treatment facility, but he still stated that he would be available via Zoom.
Okay, do you want to wait a moment?
Please, let me reach back out to him and see what's going on. Thank you.
Okay. Attorney Sullivan?
Morning, Judge.
Good morning. What case are you on?
I'm here on Kobe Boyles. I've spoken.
And Mr. Boyles is not present.
Yes, I understand, Judge. I've spoken to Mr. Boyles this morning. He should be on Zoom here any minute. I apologize for his delay.
Okay. I don't understand why. Oh. David Kennedy?
What minute? I don't even know. I don't know. Who just?
This time is we're giving you an attorney, so okay.
Thank you.
So.
Gracie's. No, it's in custody. Right now. Right now.
Ready on McIntosh?
Yes, thank you.
Okay. Call people of the state of Michigan versus Salon McIntosh, case 2355623. McIntosh is charged with 1 count of stolen property, receiving and possessing a motor vehicle set for a PCC. Appearances.
Alexander Kirker on behalf of the people, P86-282.
Jeffrey Glazer, P 46892, on behalf of Mr. McIntosh, who's here on Zoom, asking to waive his physical presence. We consent to Zoom.
Okay, Mr. McIntosh, make your name for the record.
Tyler McIntosh.
Thank you. And we were on the record earlier this morning for Mr. McIntosh's case, in which I entered a KGS 1000 personal. I will set the warrant aside. It wasn't entered in the system as of yet.
Thank you, Judge.
So you do have discovery, correct?
I don't know if I have video, Judge.
Okay, Mr. Kirker?
Yes, I reached out to the officer in charge in this case, still waiting on a response.
Okay. When did you reach out?
On Friday.
Judge, I'm comfortable either setting for another PCC or for a live exam. Hopefully I'll get to this video in time.
Okay, I'd like to set an exam. If you want a PCC in between that time, I'll do that.
No, that's fine. Let's set it for an exam, Judge. I got a bunch of dates that are, so I have a feeling we're gonna be out a week or two anyways.
Yeah, I'm trying to get it closer. We're working on it. Let's see here. Earliest date, I have March 14th at 10 or 11 o'clock.
Judge, we go to the next week.
Sure. We have the 20th, that Monday, we have a 9:30.
No, that's not gonna work, Judge.
Okay, 21st, Tuesday. There's a 9:30, 10, or 10:30 open.
I could do the 9:30 on Tuesday, 21st, Judge.
Okay. Mr. McIntosh, 9:30 sharp in person at 36th District Court, okay?
Okay.
And did you all exchange numbers so you can contact each other?
Yes, Judge,
Yeah.
I got his phone number.
Okay, anything else?
I think we're good. Thank you, Judge.
You're welcome. You all both have a good day.
Thank you.
Mr. Kennedy, David Kennedy.
Can you hear me?
Yes, what are you here for today, sir?
I'm sorry.
What are you here for today? I don't see you on the docket. I'm trying to figure out what you're here for.
They gave me this court date when I was retained the month before last.
For what? What are you here for?
It was a bench warrant I had.
What type of case?
CCW.
Your case is tomorrow at 10:30 in person. No, I'm sorry, not in person.
Well, they gave me this date too though. I know I had another date scheduled last week for tomorrow. So I don't know what they had me scheduled for today.
Okay, so your case is tomorrow at 10:30. March 7th.
Okay. So today's date, I don't have anything.
No, you don't have anything on the docket today. There'll be no warrant.
Okay.
So you can zoom in to the probable cause conference, just like you did today, 10:30 tomorrow.
Okay,
All right, have a good day.
thank you.
I'm gonna step outside to talk to my. I just got on the Boyle case and
That's right now. Okay, Mr. Boyles,
Yes,
good morning, sir.
good morning.
Your attorney is here and let's see if he is available.
Okay.
Attorney Sullivan, are you free?
Yes, Judge, I'm here.
Okay, do you need to speak to your client when she's here?
I don't think I need to speak with him before we're just requesting a preliminary exam date, Judge.
Okay. Prosecutor Parrish has something she'd like to throw on the record, so let me call the case. I'm not sure what it is. Okay, we're on the record that the people of the state of Michigan versus Kobe Raekwon Devon Boyles, 2355721. Mr. Boyles is charged with the following. Count 1, motor vehicle unlawful driving away. Count 2, attempted motor vehicle unlawful driving away. Count 3, assault with a dangerous weapon, felonious assault. Count 4, police officer fleeing 3rd degree penal code. Count 5, malicious destruction of fire or police property. Count 6, police officer assaulting, resisting, and obstructing. Today's day set for a probable cause conference.
Good morning, Your Honor. Danielle Parrish on behalf of the people, P85495.
And good morning, Judge. Neighborhood Defender Service by Andrew Sullivan, P84261. Here representing Kobe Boyles, who's present on Zoom, has no objection to appearing by Zoom. Mr. Boyles, can you unmute yourself, turn your camera on, and state your name for the judge?
Good morning, Your Honor. Kobe Boyles.
Good morning. Attorney Sullivan, do you have discovery?
Yes, Judge. I think I have complete discovery, both paper and digital discovery. We're requesting a date for a preliminary exam.
And Ms. Parrish, do you have something you want to place on the record?
Yes, Your Honor. People would like to address bond. I know it was recently addressed, but some new information has come to light since that bond redetermination hearing. I would like to put on the record of the court and discuss an increase in the bond.
I have been put on zero notice of this. I don't know if a motion is being made, but I would ask for a notice of that in writing, and so that I can prepare to respond in writing. We can schedule a.
Attorney Sullivan, it depends on what it is. If it happened 5 minutes ago, it is urgent. It couldn't be in writing. I have no idea what she's about to say. Let me hear what she has to say first, and then make a determination of whether it should be in writing.
Your Honor, this was just brought to my attention from circuit court prosecutors. It was not, I did look it up this morning to see if this was addressed previously by other APAs, and in our unit here at district court, it was not. And nobody was aware of it at the time. When bond redetermination lowered Mr. Boyle's bond to a personal bond, I would like to state that Mr. Boyle pled to another very similar charges, actually a little bit worse, pled back on February 23rd here and was found over to circuit court. Less than 24 hours, I would say roughly 12 hours, he allegedly committed these crimes. The previous case, extremely dangerous. This case is, as you see, the alleged counts don't just include, unlawful driving away. There is a felonious assault charge. There's also the fleeing aspect of the charge. And based on the information that we obtained, the fact that Mr. Boyle pled not even 12 hours before that to similar charges that also involved a minor that was in a vehicle. He didn't learn his lesson then. He couldn't even, based on the, allegedly couldn't even restrain himself for 12 hours before he went out and got these charges. And attempted to flee from officers at the same time. And it's been brought to my attention this morning that he also has a similar case in Oakland County. When I say very similar charges, these are repeated crimes that he allegedly keeps committing. The people feel that it is inappropriate to have him have a personal bond. The fact that he has multiple charges on a case in circuit court, very similar. And like, as I said, within 12 hours, these charges occurred and he fled police and has a felonious assault charge on top of that, all while also having a case in Oakland County. Your Honor, I believe for the safety of the community, the seriousness of these charges, the court, I was respectfully request that the court reconsider the bond that was given by Judge McConaughey. I believe Judge McConaughey was not presented this information because we didn't even know it at the time.
Question, before you respond, Attorney Sullivan, has anything happened since his bond was reduced on February 28th? Anything?
Judge, I didn't represent Mr. Boyles at the bond redetermination hearing. There is separate counsel that's appointed for those hearings.
Yeah, I know. Asking Ms. Parrish if anything has happened since his bond was reduced on the 28th. Has there been any incident? Has there been any charges? Has he violated his bond? Because he's on house arrest right now.
No, Your Honor, not that I'm aware of, Your Honor. I do not know when the date of the Oakland County charges are. It's just brought to my attention that he has similar charges in the county. But again, I don't feel that Judge McConaughey at the bond redetermination was provided this information. In the passing and the fact that he has not actually been sentenced on the other one, but pled to it, it fell through the cracks, Your Honor, and therefore no one was able to give Judge McConaughey this information. People believe he would not have granted a personal bond in this matter.
Mr. Attorney Sullivan, do you have a response?
Judge, again, I would reiterate that I'd like notice of all of this before I'm asked to respond. But I do know for certain, Judge, that the Oakland County case that's being referenced predated the Third Circuit case. I do represent Mr. Boyles on that case. He has pled, and he did have a Cobb's evaluation to height of probation. Certainly, Judge Judge Hathaway may very well rescind that Cobb's evaluation, and he'll have to answer for that with Judge Hathaway on the 30th when we have our sentencing. But at this point, Judge, to answer your question, there's, to my knowledge, not been anything subsequent. Nothing has happened with Mr. Boyles subsequent to the 28th when the bond redetermination hearing was held. This could have been brought to the judge's attention at that time. I wasn't there at that hearing, so I don't know what was argued and what was provided. But the judge made the determination about Mr. Boyles' bond. Mr. Boyles has reappeared for court today. If I understand correctly that he's on house arrest, I think that does address the government's concerns about safety to the community. Mr. Boyles is required to stay at home. So there should be no further issues. We'd ask that bond remain the same. We'd ask for a preliminary exam date on this case. And again, certainly Mr. Boyles will have to answer Judge Hathaway on the circuit court case, which he is, as I said, he did receive a Cobb's evaluation tied to probation. And so I'd ask the court to take that into consideration.
Okay, I am going to leave bond as is. My only concern is whether or not he has done anything since his bond redetermination hearing. And to my knowledge, he has not. He's on house arrest, tethered. We have not received any information that from the tether unit that he's violated his conditions. So I'm going to leave that alone. And Attorney Sullivan, we're looking for a date, correct?
Can I ask the DSC report be ordered?
Sure.
And I would like to put defense on notice that my supervisor will likely put in a motion for a emergency bond redetermination of this matter.
Okay, so Attorney Sullivan, I'm going to order a DSC report. That probably won't be, depending on our exam date, that probably be handled at Third Circuit if the case is sent over to Third Circuit. Okay.
Understood.
All right, so let's get an exam date. I have March 14th, open 10 o'clock and 11 o'clock as early as dates.
Is it possible to schedule this 1 week later to the 21st?
Yes, I can do 9:30. No, I can do 9, 10 or 10.
10 o'clock on the 21st would be wonderful, Judge. Thank you.
Okay. So March 21st at 10 o'clock. Okay, Mr. Boyles, you are to appear in person at 36th District Court on March 21st, March 21st at 10 a.m. for your preliminary examination, okay? Mr. Boyles, I need you to acknowledge on the record that you understand that you're to be in person.
I understand, Your Honor. Thank you.
Okay, anything else from either party?
Nothing for the people. Thank you, Your Honor.
Nothing from the defense, Judge. Thank you.
All right, you have a good day. Okay, so the gentleman in Division 2, take your name, please. Wayne County Jail in Division 2.
Ricky Carrington.
Okay, Mr. Carrington. I don't know what's going on, Attorney Schwab, with your client. I don't know where he is.
May I come back around 10:30 or so just to take care of it?
Sure, we're here all day.
Thank you, Judge.
All right. Okay, Mr. Carrington, your attorney checked in and left, so we will have the clerk contact your attorney to go on back on.
All right.
But it's not on. Okay, to the gentleman on the iPhone with the blue shirt, can you unmute your device, please? What's your name, sir?
Richard Dickerson.
Okay, Mr. Dickerson, your attorney is here. Attorney Lamb, do you need to speak to Mr. Dickerson? Mr. Dickerson, have you spoken to your attorney yet?
No.
Okay, you know your attorney is Attorney Lamb. I think we went through this already.
Yeah, I know who he is.
Okay.
I mean, we spoke a little bit, but not. I mean, I'm really not clear on what's going to happen.
Okay, you have some time for that.
I'm on my video court, right?
You have time. I just wanted to make sure you knew who your attorney was because last time
Yeah.
I was thinking.
Yeah, I do.
Okay, so as soon as he probably had another matter, the reason why he's not responding, as soon as he responds, then I'll file your case, okay?
Okay, So I stay on here or?
Yep, just down here.
All right, thank you.
You're welcome. Oh, there we go. Attorney Lamb, you ready?
I am.
Okay, do you need to speak to Mr. Dickerson?
I think we are prepared to go for purposes of PCC.
Okay. This is case 09-63590, the people of the state of Michigan versus Richard Dickerson. Mr. Dickerson is charged with one count of robbery unarmed. Mr. Dickerson is defendant number 2, also with a habitual offender third offense notice. Today is a set for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Michael Lamb, P79816, appearing on behalf of Mr. Dickerson, who's also present via Zoom. Mr. Dickerson, will you please state your full name for the record?
Richard David Dickerson.
Okay, Attorney Lamb, scared to ask, do you have discovery?
I'm sorry.
Do you have
Oh,
discovery?
no, I'm sorry. I have not received paper discovery as of yet, Your Honor.
I looked at the age of the case. I didn't think you would, but Mr. Mr. Kirker, I will let you expand.
Your Honor, at this time, we also have no discovery for this case.
Okay. Attorney Lamb, do you want to set this for an exam date or make a motion?
It's probably most prudent to maybe set another adjourned PCC date. I don't know how long it might take for me to receive that discovery, but once I receive it, I need to review it with my client. I also don't know what exactly this discovery is going to consist of.
Well, I don't want to keep adjourning PCCs when they don't have discovery.
Understood. Then I'm okay with setting this matter for an exam. Your Honor.
Mr. Kirker. Good morning to you. That hasn't been sent over.
Well,
I'm not aware of any discovery in this case.
Okay, Attorney Lamb, I will be open to an adjournment if the people provide discovery on the day before or day of the exam date.
understood.
Okay. Let's see here. I have March 14th, 10 a.m. or 11 o'clock.
March 14th at 11 a.m.
Yes.
I can do that, Your Honor.
Okay. Mr. Dickerson,
Yes, ma'am.
your preliminary examination has been scheduled for March 14th, 11 a.m. in person at 36th District Court, okay?
Okay, thank you.
You're welcome. And as I stated, Attorney Lamb, if we receive discovery at the 11th hour, I will entertain an adjournment.
Understood. Thank you, Your Honor.
Okay. Anything else?
No, thank you.
Not at this time.
All right, you all have a good day.
You too.
Thank you, you too.
Okay, Ms. Thomas, I'm still waiting on your attorney.
This is the attorney for Ricky Carrington. Did he show up eventually?
Yes, I was talking on mute. He's in custody. Do you need to speak to him?
I do.
Okay, I'm going to put you into a breakout room. Mr. Carrington, I'm going to put you in a breakout room with your attorney. Okay? Yes. Okay, we're on the record. This is the people of the state of Michigan versus, oh, I'm sorry, there's no court report. Attorney Robinson, good morning.
Good morning.
Do you have the booking sheet from the Wayne County Jail or Sheriff's Office?
I don't have it. I didn't
Okay.
know until this morning there was a hearing or a violation.
Me neither. So Ms. Boyd is going to scan it over to you. I'm going to put you into a breakout room with Ms. Thomas in the meantime, okay?
Thank you.
Ms. Thomas, I'm putting you in a breakout room. Go ahead. You might have to hit join. I'm not sure. To the person with the phone number ending in 8876, can you state your name, please?
Hi, yes, my name is Parvez Fox.
What's your last name?
Fox, Fox.
Are you calling in for a traffic matter?
What is it?
You have a traffic matter or misdemeanor today?
No, I'm trying to figure it out. No, not today, ma'am. I was just in jail and I got released from Mound, and I got this Zoom I got the Zoom meeting hearing for. I got a 2018 marijuana case. I'm on 3 bonds, 3,500.
Okay, that's a misdemeanor. I'm going to get you to the right place. Can you spell your first name and your last name?
Parvez, Parvez, Fox, Fox.
Okay, the clerk is going to look up to see what courtroom you should be in and what day you need to be in court, okay?
Yes, ma'am.
Judge, it looks like you said to come here for court March at 8:30.
Is that for marijuana? Oh, okay. So actually, you do have a case before me, but it's on March 14th.
It's on the 14th. I gotta call back with you.
Oh, I see what's going on. You have a bond redetermination hearing, but you're not in custody. So
Yes, ma'am. I'm not in custody. I'm out of jail. I'm on 4 bonds. I got bonded out 4 bonds.
So you would have had a bond redetermination hearing today, but since you're bonded out, you don't have to appear today. So your next court date is
Right.
March 18th at 8:30 a.m. on Zoom in this courtroom. So use whatever numbers you use to get to this courtroom, do that again on the 14th at 8:30.
Yeah, it's my father's number.
Okay.
So I would have to call you off my father's number.
It doesn't matter what phone you use, but the numbers you dialed need to be the same.
Oh, okay. Yeah, I was just calling you off my phone. Then the number I just could dial right now. I got it right here and with my paperwork.
Okay, what's your court date?
The court date. It says at the bottom of the bottom of the receipt. I see two dates, 3/14 and 3/21.
So come on March 14th at 8:30, same way on Zoom, just as you did, okay? And your lawyer will be here to
Okay.
talk. All right?
Yes, ma'am.
So log off. You have a good day.
You too.
Thank you.
All right.
Okay, we're back on the record. This is the people of the state of Michigan versus April Johnson, 2355029. Ms. Johnson is charged with one count of police officer assaulting, resisting, and obstructing today's date set for a preliminary examination appearances.
Alexander Kirkland, on behalf of the people, P86282.
Good morning, Your Honor. Matthew Forrest, P73168, on behalf of April Johnson, present standing behind.
Ms. Johnson, can you state your full name for the record?
April Havana Martrice Johnson.
Thank you. Our parties ready to proceed today.
The people are not, Your Honor, and the necessary witnesses have failed to appear.
Anything from the bench?
You make a motion to dismiss at this time.
Okay, time is now 9:44. Without prejudice.
Thank you.
You want anything else on the record?
No, Your Honor.
Okay, you off the record?
We're ready on Carrington.
Okay. People of the state of Michigan versus Ricky Carrington, 2355682. Mr. Carrington is charged with count 1, police officer assaulting, resisting, and or obstructing, causing injury, and count 2 as well, police officer assaulting, resisting, and or obstructing, causing injury, set for a probable cause count. Appearances.
Alexander Kirkland, on behalf of the people, P86282.
Scott Nadeau, P64316, on behalf of Ricky Carrington.
Mr. Carrington, can you state your full name for the record?
Ricky Carrington.
Thank you. Good morning.
Yeah, good morning.
Okay, any discovery issues?
None at this time, Judge.
Okay, would you like to set an exam date?
No, actually, we're gonna do a waiver today, Judge.
Oh, okay. All right, Mr. Carrington, I'm gonna ask you some questions, okay?
All right.
And if you can't hear me or if you don't understand the question, please interrupt me and let me know, okay?
All right.
And is it your wish that you would like to waive your preliminary exam today?
Yes.
Do you understand that you have a right to a preliminary exam?
Yes.
And that if you were to demand your exam today, the people would have to show at the lower standard, probable cause standard, that the charges that I just read off were committed in the city of Detroit and that you probably committed those crimes. Do you understand that?
Yes.
And that by waiving your exam today, that means that people do not have to call any witnesses or prove that. You understand that?
Yes.
Okay. Knowing that information, you still wish to move forward and waive your exam.
Yes.
Did anyone force you or threaten you to waive your preliminary exam?
No.
Did anyone promise you anything before you waive your exam?
No.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. I will have you bound over before I must ask. I'm sorry, Mr. Carter, do you object to the binder?
No objection from the people.
Okay. I will have Mr. Carrington bound over to Third Circuit Court. Since you're in custody, it'll be 1 week from today, so it'll be March 13th at 9:05 a.m.
Thank you. Good day.
You as well. You're all set, Mr. Carrington. Your next court date is 1 week from today at 9 o'clock, okay?
Okay, thank you.
You're welcome. You have a good day, sir.
All right, you too.
Thank you.
Thank you.
Ready on Ms. Thomas?
Ready, Judge.
Okay. I'm bringing her out. It may take a minute. There we go.
Thank you. Appreciate that.
Okay, this is the people of the state of Michigan versus Portia Shanae Thomas, 20-61434. Ms. Thomas is charged with one count of weapons carrying concealed. Today is the date set for an emergency hearing for a tether violation. Appearances?
Alexander Kirker on behalf of the people, P6282.
And good morning, if it may please the court, Sarah Robinson, P63181 for Ms. Portia Thomas, who's present at the Wayne County Jail.
Ms. Thomas, can you state your full name for the record?
Yes,
State your name.
Portia Thomas.
Okay, and Attorney Robinson, did you receive the report from the Wayne County Sheriff's Office?
Judge, I have received it and I reviewed it with Ms. Thomas.
So I believe this is just Ms. Thomas not showing up for a court date?
Judge, I don't understand that because I was appointed and our court date is scheduled for March the 9th. So I don't see how she's missed court.
Okay, now let's. Okay. Thank you, Chief, man. On this, for carrying a concealed weapon. Yeah.
Thank you. What's the date for the Carrington?
For March 9th.
Yes.
Okay. I'm reading through the ROA. I don't see how this, what happened here. It says an arraignment scheduled for March 2nd and probable cause set for March 9th. So I don't know why she was picked up on this case. Did we already send the damn date as well, Attorney Robinson?
Judge, I'm not gonna be able, it's March 16th, but I'm not gonna be able to keep that date. But March 9th is in my calendar. I don't know why she's in jail.
What time for March 9th?
1 second. Okay, so let me see that. Well, obviously brought to my attention on February 28th, Ms. Thomas was set for an exam with Attorney Washington. That's when I said it came for 1,000 personal. It was set for 9 o'clock, February 28th.
Exactly. That's when I looked at, I apologize.
Were you, who? Do you remember speaking to Attorney Washington on this case, for this case?
Mr. Washington has not been able to be, I hadn't talked to him since during my case at all. You understand? Like even prior to when I was in the placement, my counselor couldn't even get in touch with him about my court date. So when the 28th came, my child was sent home from school with COVID. I can't just leave him with anybody. My sister wasn't home at the time. So I called the agent and let him know.
Did you know about your court date? Yeah. Did you go to court?
I wasn't able to go to court. My child was sent home with COVID.
I said, did you call her?
Yes, I did. I could not get through the court lines. They kept hanging up, I guess, through the personal lines to reschedule my court dates. So I was trying to make arrangements to come in person and arrange it. I had to wait for transportation. They came and picked me up probably about a couple hours before I can even get someone to watch my kids and go.
Okay, so at least I can understand that the case was entered, wasn't entered in error. Okay.
Yeah.
All right, Attorney Robinson, are you now her attorney on this case?
I'm her, yes, I am, Judge, and I'd like to argue bond for her release.
Okay, go right ahead.
Judge, my client has 2 children. They're in the care of her sister right now. She is employed. She has a manufacturing job. If she's not released from the jail, she will lose that job. I'm asking that the court release her on a personal bond or at a minimum on the tether.
Okay, Ms. Thomas.
Yes.
I understand when people have life issues. If you cannot make a court date, call the court or Zoom in or do something to make sure the court knows these are serious matters. I had to put a warrant out because you didn't show up.
Yes, I do understand that.
Okay, so I will change it to a personal bond, it'll be $5,000. And your next court date, we're gonna have to schedule, schedule today? Are you prepared to schedule it?
The probable cause conference today, Judge?
You can make that today if you want.
Whatever the court wants to do.
Okay, so you don't have, do you have discovery on this case yet?
No.
Okay. Let's set a PCC 1 week out, and then the following week we'll do an exam. We'll set an exam date. I just want to get the exam date on the calendar because we're a little behind.
I understand, Judge. I have a jury trial on the 20th, which may or may not go, but I think it might, at Frank Murphy.
Okay, let's set. Can you come back on Wednesday this week for a PCC?
Yes, I can.
Okay, and we'll just schedule a date since it's so close. We'll wait till the 8th to schedule an exam date.
Yes, Judge. Can I briefly go into the breakout room? I want to make sure I have the correct phone number for Ms. Thomas, or if she can say it now, whatever if the court allows that.
I'll do a breakout room so she doesn't have to announce it on Zoom.
All right, thank you.
Welcome.
Good morning. Attorney Pope. Okay, ready, Williams? Yes. Sure.
No, sir. We're done. We haven't seen some.
Good morning.
Morning,
Jack.
morning, Your Honor. How you doing?
Hi, how are you?
Good, thank you.
Don't you have a holiday today?
Excuse me?
You have a holiday today that you're observing?
Yeah, it's tonight and tomorrow. Yeah, thank you for asking. Yeah, Purim.
Yeah. Yes, I'm aware. I remember that. So today, the exam was set for this day, but I had a feeling it wasn't going to go. All the attorneys cannot agree to a date. So there are talks of offers for some of the defendants. I don't know if your client is involved in those discussions.
I mean, practically, I mean, we have not had any offer discussions, but I mean, based on my knowledge of this case, I don't believe that we will be doing any negotiations in terms of pleas.
Okay. So the next, I have a probable cause count, a PCC set for March 8th for defendant number 5 to discuss their possible plea. And after that, then I can set an exam for everyone else. We're down to 7 from 10 as far as setting dates. So this will be a little bit easier.
Okay.
So do you want to just wait till tonight email after the 8th?
Yeah, if that's okay, that makes the most sense.
Okay, all right, I'm trying to make sense of this.
I appreciate it.
Okay, so I'm sorry, I didn't even ask you, did you have anything you wanted to address? I just started talking.
No, it's okay. No, thank you. At this time, I'm, my understanding based on the report is that there is electronic discovery, including video, and so that's still outstanding. And I'm not sure that. So that's my only issue in terms of that.
Okay, we're off the record, but Mr. Kirker, I remember on this case, I think Mr. Decker spoke on it, that the discovery, the wrong digital was sent, and that was going to be corrected. Do you remember that? This is the tentative
Yes,
case.
I do remember that.
Okay.
I don't have an update on that aspect right now.
Okay. So, Attorney Jaffe, Mr. Decker is the APA who discussed sending the correct digital discovery. I will ask him tomorrow to make sure he sends it out.
I appreciate it. Thank you very much. And then, yeah, just keep me posted in terms of the dates. That'd be great.
Okay. All right. Enjoy the rest of your day and your holiday.
Thank you very much. Thank you so much. All the best. Bye-bye.
Bye. No. Yeah, because we don't have a real date. Tell them to be the next couple weeks. Okay.
Judge, I did hear you call my name.
Yep, give me 1 second. Ms. Thomas,
Yeah.
I didn't see what time. It's 8:30 for your probable cause conference. It'll be on Zoom. You do not have to be in person.
Okay. Thank you so much. You got that, Sarah?
Yes, I got it. You say in person or Zoom, Judge?
Zoom.
Zoom.
All right, thank you.
All right, you have a good day. Okay, Attorney Pope, good morning.
Good morning, Judge. I have 2 matters scheduled for tomorrow, and I need to adjourn them. I'm not in a position where I can come in person. I'm under a COVID quarantine.
Okay. Can you call Madam Clerk to discuss that?
Yes,
Okay, it's
right.
9:16.
I have the number, Judge. I'll contact her.
Okay, all right.
All right, thank you. All right, I just wanted the court to be aware and the prosecutors in case they have witnesses so that they wouldn't call the witnesses for tomorrow.
Okay, I appreciate it.
All right, thank you.
Thank you.
Yeah.
Go back to Mr. Wood. We are on the record, this is the people of the state of Michigan versus Robert Clyde Williams, 2260043. Mr. Williams is charged with 1 count, police officer assaulting, resisting, and obstructing. Today's date is set for preliminary examination appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Neighborhood Defender Service by Summers Brush, number 85828, hearing on behalf of Robert Williams, who is present behind me in the courtroom today.
Oh, I forgot, we're waiting on this carriage.
Yeah.
Well, Mr. Williams, since we're on the record, so please state your name, your full name. Okay, good morning. And we're waiting on Ms. Parrish to come and visit her. You can have, let's say you can have a seat. Okay, we're on the record. Everyone's put their appearances on. Ms. Parrish?
Morning, Your Honor, Danielle Pierce on behalf of the people, P85495.
Okay, any preliminary matters?
Here.
Yeah, the people would just like to put the court or defense on notice that, it's likely that the testimony, will bring to light that additional charges will be added after, or requested to be added afterwards. I have mentioned it to defense if I go over that.
All officers. They have.
Anything else?
After the people.
And just for the record, there's no one else in the courtroom other than the defendant, attorneys and staff. If there's anyone on YouTube who may testify in this case later on, now I'm asking to log off. The representative here should call you first.
Thank you, Your Honor. I want to say the name correctly. People call Mr. Ignacio Hood.
Here.
You for tell the truth, don't do that. Have a seat right here. It's in the front, the door. Okay, just make sure you speak up. And before you begin, Ms. Parrish, there's someone who else comes to the courtroom.
Yes, Your Honor, I'd like to put on the record that the OIC has entered the courtroom. I have indicated that to the defense as well. He does not plan on testifying.
Any objection? No, Your Honor. No objection. Whenever you're ready, Ms. Parrish.
Thank you, Your Honor. So I'm going to ask you a series of questions. If you could kindly just speak directly into the mic, it is adjustable. If there is something I ask that you do not understand, please stop me. I'm happy to rephrase the question. Could you please restate your name for the record, sir?
Name is Officer Ignacio.
Also, just because I'm a little hard hearing and I want the court reporter to hear everything, can you just bring that a little bit closer to you? Thank you. So, will you please tell the court where you're currently employed?
Currently employed with the Detroit Police Department,
And in what capacity?
police officer,
How long have you been a police officer, sir?
a little over 2 years.
Were you employed as a police officer with DPD on October 9th, 2022?
Yes,
Were you by yourself or with a partner that day, sir?
I was with the partner,
Okay, and what is your partner's name?
John Rick,
Sir, were you and your partner in full or modified uniforms that day?
full uniform.
And were you in a scout car?
Yes,
Was your scout car fully or semi-marked?
fully marked.
Did your duties as a police officer take you at or near 13611 West 8 Mile Road in the city of Detroit, County of Wayne?
Yes,
Could you please tell us why were you near that location or what were you doing near that location that day?
I was on patrol that day.
Just to clarify, were you the driver or the passenger of your scout car that day?
I was the driver.
While at or near said location, officer, did you observe something that drew your attention?
Yes,
What was that, sir?
I was on patrol, traveling westbound on West 8 Mile Road. I was going about 40 miles an hour. That's how I paced vehicles to see if any speeders are in the area. And there was a Ford Escape that went past me on my left side at a high rate of speed. So I initiated the traffic stop.
You said it was a Ford Escape?
Yes,
And why were you initiating a traffic stop, sir?
for that driver speeding.
When you say you initiated a traffic stop, can you tell us what that entails? What you did?
So I got behind the driver, turned on my lights and sirens to signal to the driver to pull over.
Okay. Did the driver of the Ford Escape immediately pull over?
No, we initiated the traffic stop at about West 8 Mile Road at Hubble. The driver continued to travel until about 8 Mile and Shaper.
And you say your lights were on and you were right behind him?
Yes,
Okay. And within this entire time while he continued, where your siren was on as well?
yes.
Okay. When he did not initially stop, did you continue pursuing him?
Yes,
Okay. Did he eventually, did the Ford Escape driver eventually pull over?
yes, he pulled over into a Church's Chicken parking lot.
What type of business was it again, sir?
Church's Chicken.
Church's Chicken. When the driver of the Ford Escape pulled into the Church's Chicken, sir, did the car come to a complete stop?
Yeah, the car came to a complete stop. The driver immediately exited out of the vehicle. I got on my intercom and asked him to get back inside of the vehicle, which he refused.
How far was your vehicle, your scout car, from the driver's vehicle when you got on your mic to tell him to get back in his vehicle?
Probably about 2 car lengths behind.
Okay. How did, okay, so let me first ask you, would you be able to identify that person, that driver who exited his vehicle?
Yes,
Is that person in the courtroom today, sir?
yes.
Could you please tell the court where that person is in the courtroom and article of clothing that they're wearing?
I'm sitting right behind you in a gray hood.
In a what?
Gray hood.
Your Honor, may the record please reflect the identification of the defendant, please, or reflect it. Thank you. Once you told the defendant to get back in his vehicle, did he comply with your orders?
No.
Did he proceed to do,
So once the defendant got out of the vehicle, he immediately turned his back to me and started making movements in front of his body. So that triggered me to exit the vehicle and verbally yell to him to get back inside the vehicle.
what was your partner doing when you exited the vehicle?
My partner was trying to get in contact with dispatch to let them know where we were, our location, what we were doing as far as this traffic stop.
Once you exited the vehicle and gave him verbal commands, what were the commands that you gave him?
I asked him to get back inside the vehicle again.
Did he comply with your orders at that time?
No.
What did you do after you failed to comply with your orders at that time?
I started to walk towards the defendant to get closer to him. As I started to approach, the defendant took off running southbound on Shaker.
On what street?
On Shaker.
Okay. Did you pursue the defendant?
Yes.
What did you observe your partner do at this time?
My partner was behind me, so I couldn't see him at that time.
When you say your partner was behind you, was he still in the vehicle?
He had got out the vehicle, but the way the vehicle was positioned, when the defendant started running south through the parking lot to get to Shaker, when I took off behind him, my partner had to come around the vehicle to, continue to pursue. So he was behind.
So did you observe your partner pursue him as well?
No, I did not.
Okay. So now you're pursuing the defendant on foot?
Yes.
How far would you say you pursued the defendant?
Not exactly sure how far it was foot-wise. Went through a parking lot, down a couple businesses down on Shaver.
Okay. During this time, did you give the defendant any further commands?
Yes.
Okay. What were the commands that you gave?
I told the defendant several times to stop running.
Okay. Did he comply at any time?
No.
At this time, toward the end of your chase, or as you're indicating, you failed to comply. Were you able to see your partner at that time?
No.
And so, what happened after he failed to comply with these verbal commands while you were still stood on foot?
I gave the defendant a verbal command that if he did not stop running, he would be tased. He continued to run. He didn't comply after that verbal command.
How many times did you tell him that do you recall how many times you told him to stop?
I don't recall exactly how many times I did.
Did you repeat yourself in regards to the threat to taser?
I don't recall.
Okay. After telling him that you were going to use your taser, did he slow down? Did he stop? And how, I'm sorry, go ahead.
No, he didn't slow down.
How far away were you from him when you gave him these commands?
I was within 10 feet.
Within
We
10
got
feet.
pretty close to each other.
Okay. After you failed to comply with your order to stop, and you're giving him notice that you were going to use your taser, what happened next?
He continued to run, so I deployed my taser the first time. It took partial effect. I could hear the defendant. He had made it like a grunt noise, and he continued to run down the street. So,
Right, so when you say it made a effect, so you actually observed it touch the defendant?
I observed it touch his clothing. The reason it made a partial effect, the way the tasers work, if both prongs don't take effect, it won't, how do you say, interlock your nervous system. So it'll be a pain compliance tool, so you'll feel it in one area, but it won't take full effect.
Okay, and you said that you heard a response from the defendant when that occurred?
Yes.
Okay. Yeah, you said he did not stop at that point?
No, he continued to run at that point.
Okay. When he continued to run, what did you do at this time?
So I deployed my taser the second time, and then the second time it took full effect.
When you say it took full effect, what did the defendant stop?
Yeah, because the defendant fell to the ground.
Okay. Once the defendant fell to the ground, were you still by yourself pursuing him? Or where was your partner at this time?
So at that time, I noticed my partner was with me. So I had my partner immediately place the defendant in handcuffs and sit him upright while I called on the radio to get EMS to the location and the supervisor.
So you called for your supervisor and EMS. Is that normal procedure when you use a taser?
It's normal procedure, but then we also want to make sure EMS gets there to check anyone out medically.
After the defendant was on, I assume he was on the ground. You say he fell to the ground? Is that correct, on the ground? Okay. Was he placed under arrest?
He was detained, and then we waited for EMS to get there first, and then that's when we continued our investigation after they.
So you continued your investigation after EMS arrived? Was he placed in handcuffs?
Yes.
And who placed the handcuffs on him?
Excuse me?
Who placed the handcuffs on him?
My partner.
Your partner? Was there any resistance during that time?
No.
No further questions at this time. Thank you, Ross.
Morning, morning, Officer Hood.
Good morning.
So, you testified that you pulled Mr. Williams over for speeding, right?
Yeah,
And, what was the speed limit in the area?
the speed limit on S8 Mile Road is 40 miles an hour.
And how fast do you think Mr. Williams was going?
I know he was going faster than 40 because he traveled past me at a high rate of speed.
But you don't know how many miles over exactly.
Not exactly.
Were there any other cars on the road?
There was other cars on the road as well.
Were any of them speeding?
No.
And, you testified that you pulled Mr. Williams over and he eventually stopped his car
Yeah.
in the parking lot.
Yeah.
And you eventually pursued Mr. Williams, right?
Yeah.
You were on foot, right?
I
Sorry, I'm sorry, you were on foot when you pursued
Yes.
him. But your body worn camera footage was not active, was it?
No.
Your partner's body worn camera footage was not active.
I don't believe so, no.
And it's department policy to have that body worn camera footage active, right?
When they are available, yes.
It's policy so that we can see what happens in these interactions.
Yes.
But we can't see because you didn't have your body worn camera footage on.
Correct.
And so no video captured the pursuit of Mr. Williams. Is that correct?
Outside of our camera on our vehicle, the camera on our vehicle captures everything that happened from the stop of the pursuit.
And so then when you were running after Mr. Williams, that was when you left the area of the car, that was not captured on video, right?
Not from our department cameras, no.
Okay. And so there was no footage that showed you chasing him, right?
Correct.
There was no footage that showed his reaction, right?
Correct.
There's no footage showing the manner in which Mr. Williams was handcuffed after he was tased.
From our department, no.
Are you aware that Mr. Williams ended up suffering severe medical issues after being tased by you?
No.
Are you aware that when Mr. Williams was transferred to Wayne County Jail that he suffered a seizure?
No.
Now, are you aware of the Detroit Police Department's use of force policy?
Yes.
You've been an officer for 2 years, correct?
Yeah.
And so you are aware of your responsibilities as an officer to employ de-escalation techniques, correct?
Yeah.
Oh, no. You're aware that you should avoid force whenever possible, right?
Yes.
Hello?
And how long did your pursuit of Mr. Williams last?
Time frame, I'm not exactly sure. I was more focused on handling the situation at hand. I don't know the time frame.
So you can't estimate how many seconds, how many minutes?
No, I can't.
And after Mr. Williams fell, after the second deployment of your taser, your partner, Officer John Risky, he told Mr. Williams to put his hands behind his back. Is that correct?
Yes.
Even though Mr. Williams was lying on the ground having been tased. Your Honor. were other officers that came to assist in Mr. Williams' arrest, right?
Yes, my supervisor came and another scout came to transport Mr. Williams to the hospital.
And their body worn camera footage was active.
That I'm not sure.
Okay, but yours was.
Yep.
No further questions.
Just a couple of questions, officers, to clarify. In regards to body worn camera, do you recall if you were issued body worn camera that day?
We were not.
So you actually, it wasn't that the body worn camera wasn't on, you actually didn't have body worn camera on that day, like
Correct.
on your person?
Correct.
Okay, do you recall why you weren't issued body worn camera that day?
We didn't have any available at roll call.
Okay. So this was not a choice by yourself or your partner?
No.
Okay. But did you attempt to get body worn camera over a shift again?
Yeah.
Just wanted to clarify that. And also, defense asked in regards to the partner making a command after the second deployment of the taser.
Yes.
So did you observe that your partner was there when you deployed it the taser the first time, when you indicated that the defendant kept running?
I didn't observe my partner until after the second deployment.
Okay.
That's when I asked him to place the defendant in handcuffs because I wanted to make sure I kept the taser separated from everything, it didn't get lost or any accidental retasering occurred.
Questions, thank you.
No further questions. So then you can sit down, right?
Your Honor, no further questions at this time.
Okay, any other witnesses?
Oh, do you have any more witnesses?
No, Your Honor, no further witnesses from the people.
No witnesses to the defense.
Okay, whenever you're ready, you can.
Thank you, Your Honor. People move the defendant, Robert Clyde Williams, to be found over on count one, police officer, assault, resisting, obstructing. At this time, we are not going to request additional charges, and we reserve argument. Thank you.
Thank you. The defense at this time asks to dismiss count one, and this case not be bound over to what they said it was. First of all, Your Honor, this is a failure of Detroit Police Department, this case. It is the police department's responsibility to use their resources effectively to ensure citizen safety. And we don't have any evidence, body worn camera evidence, to show what Mr. Williams went through. Tasing is serious use of force, and Mr. Williams suffered serious injuries at the hands of the police, and here he is in the courtroom facing a felony charge for that. I understand that Officer Hood was not issued his body worn camera footage today. So it wasn't his personal fault. It was the fault of the Detroit Police Department to not issue that to him. Neither one of those officers had that footage on them. It's incredibly problematic, especially when we think about what we're facing at large in this country. There are specific policies in place like the use of body worn camera footage, the use of force policy, which is supposed to give police officers techniques, de-escalation techniques, and other alternatives to higher levels of force before resorting to force. Officer Hood does not remember even how long the pursuit lasted before he decided to deploy his taser not once, but twice. Frankly, no wonder Mr. Williams ran away from police. Exactly what he probably feared happened. And this happened at a traffic stop, at a routine traffic stop, where it's clear that Mr. Williams wasn't going an incredible amount of speed over the speed limit. They were able to pull him over and resorted much too quickly to the level of force that they employed in this instance. And for this reason, for the excessive use of force and for the failure of any video evidence by either of the officers to show what really took place between Mr. Williams and those officers, I'd ask him to dismiss.
There's testimony indicated valid stop. Officers were driving speed limit, and a vehicle passed them at a high rate of speed. Therefore, they, based on the experience, knew that the defendant was speeding and opted to initiate a traffic stop. The charges are assaulting, resisting, or obstructing a police officer. I believe that in this case, not only did the defendant oppose the traffic stop, he also resisted all commands from the officer. As testimony indicated. Not only did he not stop initially right away, we will give him the benefit of the doubt, as I'm sure officers did, and thinking that maybe he's pulling over into the Church's Chickens to be in a safe area. Yet, once he did stop, he immediately exited his vehicle, and according to testimony, not only once via a PA system, but also verbally was told to get back into his vehicle. He then pivoted his body and proceeded to flee from the area. Also, at that point, immediately at that point, probable cause has been met for count one. And then the officer further entails the fact that he pursued the defendant, which the people can assume that his partner pursued too, because eventually, once he did stop, his partner was there and was the one who put the handcuffs on the defendant. But he pursued him. While pursuing him, he warned him to stop. He also warned him that he would use a taser if he did not stop. He used the taser eventually, and it did not take fully. Yet that still did not deter the defendant and have him stop and comply with the multiple orders given. Now, I understand what defense is saying. Of course, officers want to do their best to avoid having to, use force in these instances. But you have someone that is actively resisting and not complying with officer orders, putting not only the officers, but community at danger while they're running away from officers. Officers don't know why he's running. This is a simple traffic stop that could have just easily been handled, but now you have the defendant running. Therefore, unfortunately, in this instance, he did have to use force and use a taser, but the defendant was warned several times and he did not comply. The second time, it did take effect. And as the officer said, they called EMS as well as supervisors due to the use of force. But this case should not be dismissed just because, unfortunately, use of force had to be used because of the numerous times the defendant failed to listen to orders. So as I stated, people believe that probable cause has been met and ask that this be found over to circuit court. Thank you, Your Honor.
Okay, the court heard testimony from Officer Hood. Without having to go through each fact. Try not to do each fact. Stated that he observed the defendant driving his vehicle above 40 miles per hour based off of the technique the officers use called pacing, where they drive the speed limit of on the road, and any vehicle that goes past the vehicle is considered speeding. He said that the defendant was traveling at a high rate in a fully marked vehicle in full uniform. Then he activated lights and sirens, and that the defendant finally pulled over while traveling on 8 Mile and Schaefer. And Officer Hood said that he activated the lights around Hubble, approximately about a half a mile, just off of my own knowledge. That was not a testimony, however. And then the defendant got out of the car, and that is when Officer Hood asked the defendant to, and demanded them to get back to the car. And after him to get back in the vehicle, the officer walked towards the defendant began to run on Schaefer, and Officer Hood pursued the defendant on foot. And that is when the traffic stop turned into more than defendant speeding stop. This is when it was escalated to a felony, which would be this charge. Officer Hood then goes on to state that the defendant ran at the parking lot at a couple of businesses, gave further commands to stop running several times. The defendant did not comply. Then said, if you don't stop, you're going to be paid. The defendant kept running. Within 10 feet giving those commands, Officer Hood testified. He deployed the taser, it made a bunch of noise, and kept running, and then Officer Hood deployed the taser a second time, which the defendant fell to the ground. And then he was handcuffed and sat upright. Medical EMS was called for the. I do believe that people have met their burden of proof for the charge here, but as Attorney Rush mentioned, I'm bothered. I will change the mind over here, but I'm highly bothered by the continual excuses and responses of its policy and decision makers that are protecting the police department from certain bad behavior. There's no reason why both officers shouldn't have had body cam on their body. The taxpayers pay money, and that money goes to the police department, and it should definitely everyone to have body cams. In the event that they don't have, for 2 officers, one of those body cams from another car where there were 2 body cams that they used, so at least one partner could have a body cam. Now that's policy. I don't work for the police department, nor can I make decisions, but it seems to me like that would have been a practical and made more sense decision. We have a witness here who was not a supervisor to make those decisions or to answer as to why that didn't happen. But it's problematic because I would have I want to see body cam footage of what happened, but we won't see that because there wasn't. So that's just me stating my disdain once again for certain policy decisions made on the police department. Nevertheless, it doesn't change testimony that Officer Hood provided. That the defendant did what we consider obstruct the officers from doing their job. So with that, I will have defendant Mr. Williams bound over for bringing on the information. Since you're out of custody, it will be on March 20th at 9:00 a.m. at Frederick Public. Off the record. Okay, case 2355487, the people of the state of Michigan versus Muhammad, no, call it Muhammad Ali Al-Qaidi. Mr. Al-Qaidi is charged with 1 count of reckless driving causing death with a felony commission with motor vehicle adult advisory. Today's date set for a preliminary examination. Appearances.
Good morning, again, Your Honor, Mark Fedora for the people, 376177. Good morning, Your Honor. It's my pleasure to please this honorable court to adopt P824923 on behalf of Muhammad Al-Qaidi, who stands to my right today for a preliminary exam. And your name for the record, nice and loud.
My name is Khalid Muhammad Ali Al-Bukhari. Your Honor.
Good morning to everybody. Okay, I have a form here for a bind over. It's going to be a waiver.
Yes, Your Honor, I've had an opportunity to discuss the matter with my client at this time. Today's time and next set for a preliminary exam. Where the people must prove by probable cause that a crime was committed in the city of Detroit, County of Wayne, and by probable cause that Mr. Al-Bukhari committed that crime. Knowing and intelligently knowing that information, we ask the court to kindly and respectfully waive the formal reading and bind us over to Wayne County Circuit Court for further proceedings.
Any objection from the people?
No objection, Your Honor.
Thank you for doing the work.
Yes, Your Honor.
Okay, just a couple more questions. Did anyone forcibly ready to waive your exam today? No. Did anyone promise to indicate to waive your exam? Okay, I find waiver to be freely, understandingly, and voluntarily given. I will have you bound over to Third Circuit Court, Framework of Justice for the regular information, March 20th at 9:05 a.m.
And Your Honor, if I be so, if the court would kindly allow me to address bond just for a moment.
Sure.
Mr. Al-Bukhari is currently on a tether. He's been on a tether, no violations. He does desperately need to go back to work. He needs funds to not only survive, rent, food, and pay counsel, and amongst other things. He understands he's not driving. He did not drive today, has not been driving, has no violations. He does have employment. All he's asking for is we can Uber or Lyft and or family or friends to drop him off to work. He's asking, have his work schedule, Your Honor, if you'd like to place it on the record.
Yes, and then I'll let the people respond.
Your Honor, he was working as an attendant at a fuel station. He has the option of working mornings and afternoons, and some days he catches half of another shift. It would start at 9 a.m. and if he catches part of another shift, he could work as late as 10 or 11. But I leave that to discretion of the court as he desperately needs to return to work.
Your Honor, so we're not in opposition to the defendant being able to go to work while on tether. I just would stress to the court, we would like the conditions as far as tether to remain and also no driving at all. The defendant does have a driving record that's rather concerning. With those conditions, people have no objection.
Okay, I think both parties are reasonable right here or with the request, and I am going to allow you, Mr. Al-Bukhari, to work. What the tether unit requires is proof of employment and the time. So they want very specific instructions from me, so that you won't violate your tether conditions. So I'm going to continue the bond as far as no driving, that condition. You cannot drive, catch a lift, get dropped off, however you need to get there. But you need to provide to the tether unit the locations of the gas stations or where those locations are and the shifts in which you are going to be working. So if you think you're going to be working both shifts, provide both of those times up front. Okay. And I'm going to write down now, what were the times for the two shifts?
Your Honor, as early as 9 a.m.
Okay.
And the latest would be between 10 and 11 by the time he gets home. If he gets out at 10, he might be home at 10:30 or 11.
I'm going to put here from 9 a.m. to 11 p.m. allowed to work.
Yes, Your Honor.
And it's 2 possible. And what is the location? I'll take that down now.
I have not. I know which location. So there's multiple stations that he worked at, but if he may give that to the tether unit himself,
okay,
the exact address, but it will be in the city of Detroit. Yeah. In the county.
Okay. Did I miss anything? No. Okay.
Nothing from the defense, Your Honor.
Anything else?
Nothing. No, Your Honor.
Okay.
Pleasure being in your court.
Thank
you, Judge.
Thank you.
Yeah, that's fine.
$50,000 cash. I'm sorry. Okay. Because the always does need to have $50,000 cash. I'm trying to understand the post of that. In the system. Good morning. How are you?
I'm fine.
Ms. Lee? How are you, Ms. Lee? Okay, we're on the record as the people of the state of Michigan versus Harmony Sneed, 2355378. Ms. Sneed is charged with 1 count of uttering and publishing, set for a preliminary examination today. Appearances?
Alexander Kirker on behalf of the people, P86282.
And good morning, Attorney Kevin Basant, P71061, we have Ms. Harmony Sneed, present sent to the right.
Ms. Sneed, can you state your full name for the record? Harmony Sneed. Good morning to you. And our parties proceed today.
The people are prepared to proceed. The defense counsel has explained to Ms. Sneed her right to a exam in this matter. This time she wishes to waive that right. She has executed the waiver for her. We have to this matter be found over.
Ms. Sneed, I'm going to ask you a couple questions, okay? If you don't understand or if you can't hear me, please say something, okay? You got to say yes or no. Okay. Is it your wish to waive your preliminary exam today? Yes. You understand you have a right to an exam. And that if an exam were to be held, people will have to show at the probable cause standard, not the beyond a reasonable doubt standard. But the probable cause standard, that the charge that I just read off was committed in the city of Detroit, and that you probably committed that crime. You understand that? And that by waiving your exam today, that people do not have to call you witnesses or prove that. You understand that? Yes. Okay, and knowing that information, you still wish to waive your exam? Yes. Did anyone force you or threaten you to waive your exam today? I didn't hear you. I didn't hear you. Did anyone force you or threaten you to waive your exam today? No. Did anyone promise you anything for you to waive your exam? No. Okay, I find your waivers to be freely, understandably, and voluntarily given, so I'll have to bound over to Third Circuit Court Framework of Justice across the street for your arraignment on the information of March 20th at 9 o'clock.
Thank you very much, Adam.
Fine.
Thank you.
You're welcome. Anything else on record?
Nothing from the defense counsel.
All right, you all have a good day.
You too. Thank you, Judge.
Chambers, good morning.
Good morning, Judge. Deshaun Perry was originally scheduled for a prelim today. That's one of the jail cases. Oh, I want to be sure we weren't on the docket.
So it was scheduled today, but that's only because we could not get an adjourned date for everybody. I know your client is not part of this getting a new date conversation. Is that correct?
Yeah, I mean, he shouldn't be. My client's case is set to be dismissed. I don't know if the people from that side and this side are all together on this, if they have the same plea agreement form that I have. I'm trying to send that over to the courtroom prosecutor, hopefully today.
Yes, I would love for your case to be dismissed and removed from the discussion so you can move forward.
Yeah, I agree.
Who have you spoken with so far?
Well, so the plea was done and approved by Kim Miles from the prosecutor's office. Courtroom prosecutor was, give me one second. Draw the blank.
What's the court date on Sneed? 3/20.
Natea Scott, Judge, was the courtroom prosecutor, so she has the form, and she was going to forward that form to the individual APA whose name was on the ROA. That was not the same prosecutor who was involved in the email communication, so.
Okay, all right, Mr. Kirker, can you contact Ms. Scott?
Yeah,
To see if,
come in now.
we can get this case dismissed?
Yeah.
So, it'll be one less than 50.
Oh.
Okay, all right, Attorney Chambers, so we should have something in the next few days.
Okay, should I, and I'm sorry, Judge, you said you should have something when?
In the next few days, Mr.
Okay.
Kirker is going to contact Ms. Scott.
Well, I'm around. You guys have my number and email. Just let me know.
Oh, thank you for checking in.
Thank you. Appreciate you.
All right, have a good one. Back to the person with the hand up with the iPhone, with the camera off, can you please state your name?
Carlos Cozy.
What are you here for today, sir?
I'm here to get my to hear my plea.
How do you spell your last name?
COSEY.
You said C
Yep, COSEY.
and Carlos, CARLOS?
Yep.
One moment. Oh, he said you- That's what- So you had a case at 8:35 in the morning,
Yeah.
it's 11 o'clock now, sir.
Oh, they had my phone had logged me out and they came back in. They told me to wait for the host to come back in for the judge.
Okay, you're in the wrong courtroom. You should be in Judge Stanford Jones courtroom.
How'd I get there?
435. So did you use the Zoom app? I can give you the Zoom ID.
The Zoom ID?
Yes, let me know when you're ready.
Yeah.
360.
Yeah.
435
Yeah.
0000.
Okay.
All right, let them know you were in the wrong courtroom. That might help you out.
Okay.
All right, have a good one.
All right.
Mr. Gracie still downstairs?
Oh, he's up there. He's here.
Oh, like right here.
Yes, ma'am.
That's why you were asking where the turn.
Yes, ma'am.
Quit on. Okay, so 3, 4. Question. Good morning.
Good morning. Just a moment, I'm bringing him down.
My shit already in session?
Here you go.
Here. Hey. Hey, Grandma, I gotta pick up the phone, though.
No?
They gonna hear me through there, I'm gonna hear them.
Yeah, you're gonna hear him. Yeah, they've already talked through there.
Mr. Johnson, can you hear us?
Yes, ma'am.
Okay, we can hear you just fine as well. We're gonna have to go through a couple of preliminary discussions and then we'll get started with your case, okay?
Yes, ma'am.
All right, we'll have Gracie in custody. Not in the way. Can you call and let them know we're getting ready to hold like a phone? Okay.
Excuse me, can I ask a question?
You can ask it as long as it's not about the details or what the alleged charges, what happened on that day and time. Yes.
No, it's not. I was just trying to see, was this my attorney over here present?
Yeah. Yes.
Okay, thank you. Okay, thank you. That's all I wanted to know.
Yep, we're not gonna start without your lawyer.
Thank you.
We're trying to handle one matter before yours because yours is gonna take a little more time. We have a quick matter I want to get out the way, if possible.
Yes, ma'am.
This is a reminder, one says they're on their way. That person said that about 20 minutes ago. Everyone was sitting there for 10:45. So I'm asking the court for a 5-minute grace period. If they're not here by 11:05, then we'll be prepared to proceed with the case. And I'm expecting the potential new person. I'll ask her to please help.
We're waiting on Attorney Schwab anyway. So, okay. Great. Okay, can you bring out Mr. Gracie?
Yes, ma'am. No, you're fine.
Sure.
We actually have your client.
And thank you.
Yeah, thank you for calling in. Mr. Brady? Okay, this is the people of the state of Michigan versus Shondell Bracy, case 22-60193. Mr. Bracy is charged with count 1, home invasion, 1st degree. Count 2, weapons, firearms, discharge, enter at a building. Count 3, assault with intent to do great bodily harm less than murder or by strangulation. Count 4 and 5, also assault with intent to do great bodily harm less than murder or by strangulation. Count 6, weapons, firearms, possession by a felon. Count 7, assault with a dangerous weapon, felonious assault. Count 8, weapons, felony firearm with a second offense notice. Count 9, count 10, count 11, count 12, count 13, and 14, all weapons, felony firearm with a second offense notice. Also with the habitual offender enforcement notice, today's date actually set for a probable cause conference, even though the docket says a preliminary examination. Appearances.
Alexander Kirker on behalf of the people, P86282.
And good morning, Your Honor. For the record, James Schloff on behalf of the defendant, Your Honor.
And can you state your full name for the record, sir?
Sure, no question.
Good morning to you. Okay, Attorney Slot, is it my understanding you do not have discovery yet, correct?
I have one 4-minute video and that's it.
Okay. Mr. Kirker, any insight on that?
No, instead I can send over all discovery that we have today.
Okay, Attorney Slot, I don't know if you can hear, Mr. Kirker says he's gonna send over all discovery today.
Very good.
Okay, do you, feel comfortable setting the exam date?
Yes, I do.
Okay, your client is in custody. I have March 14th at 10 a.m. open as earliest date.
Could it be a little bit later that same morning or you are filled?
I will make room. Let me see here. 11:30?
That'll be fine.
Okay, that'll be the last case for the morning.
I would also like to address bond, if I may.
Go right ahead.
Your Honor, these are serious charges, of course, but they are alleged to have occurred several years ago, I believe. And my client, of course, denies any participation, asserts his innocence, but at the same time has not been any trouble since that time. He does have a past criminal history. He will acknowledge that as well. I believe they are for low severity offenses, but as the court also knows that on all of his occasions, when his case has been pending before this court, family members have been tuning in, as well as two this morning, Your Honor. So he does have good family support. He does have a place to return to, but unfortunately, he also has some very serious medical problems that are not being addressed presently by the Wayne County Jail. So for all those reasons, Your Honor, I would ask for a substantial reduction in bond. I believe he understands the importance of coming to court, staying away from the complainants in this matter, and I'll be around for him when he needs any questions answered as to how to proceed until that next date. So I would ask that you allow him to be out so he can help in his defense.
Mr. Kirker.
Given the nature of the charges, Your Honor, the people would ask that bond remain the same in this case.